Good morning, everyone. Good morning to the ones that are listening to us from different European countries, and good afternoon to the ones that are listening to us directly from China. So for the Europeans, I hope that you had a nice Easter break, and it's really my great pleasure to welcome you to this webinar. My name is Sara Medina. I'm a member of the board of SPI. And SPI, we are a consulting company with a focus on science, technology, and innovation. We have 85 full-time people, and we have been operating in China already for more than 20 years. So it's my great pleasure to be presenting you today this another webinar, this time about IP protection in China for innovative European SMEs. So SPI is coordinating this ENRICH in China initiative, and we have different activities going on, from webinars to workshops, also missions that we plan to continue again next year. Also, we have our community with the members, with soft learning zones, with service providers that my colleague Johnny Penn will present more in detail. So I'd like to thank very much each of you for being with us today. We have more than about 70 registrations for this webinar from different European member states and also from China. And I'd like to thank very much Alexander and Catherine from the IPR SME Helpdesk in China that we have been already cooperating for many years for all the support in organizing together this webinar. So they will be the speakers, and they will tell us about all the IP issues on how to handle with the European SMEs in China. And Catherine will explain very much in detail and will be also available to answer your questions in the end. So again, many thanks for being with us, and I'll pass now the floor to my colleague Johnny Penn, that will be introducing about this webinar more in detail, the speakers, and also some information about ENRICH in China. So many thanks again, and we stay in touch, and I'll be also with you towards the end of this webinar. Thank you.
Okay, thank you, Sarah, for your opening. So good morning, everyone watching us from Europe, and good afternoon to everyone in China. Welcome to ENRICH in China webinar on IP protection in China for innovative European SMEs. My name is Johnny Penn from SPI China, and I will be the moderator of this webinar. This webinar is being organized by ENRICH in China, a European network of research and innovation center and hubs in China, in collaboration with China IPR Helpdesk. And this training targets innovative SME interested in exporting their solutions to China, and will offer useful tools to develop the IP strategy for the Chinese market. So this webinar will have the duration about 1 hour, and including the question and answers. And our keynote speakers are Alessandra Caprilia. She's a project executive from the China IPR Helpdesk. And we have the Catherine Heng Yee HUYNH. She's the IP data protection lawyer from the China IPR Helpdesk expert. So let me just briefly introduce the first speaker. Alexandra is the project executive at the China IP SME Helpdesk. Before joining the Helpdesk, she lived in Beijing and worked in Zhongguancun Science Park, where she supported foreign tech companies and supervise international cooperation on startup support, as well as executive G2G initiatives. And our second speaker, Ms. Catherine Heng Yee, is a bicultural IP and data protection lawyer. She founded her own boutique law firm so as to make the SMEs benefit from her experience in big firms. She worked in France, mainland China, and Australia. She was previously an in-house counsel for a French multinational company based in Shanghai, successfully leading an anti-counterfeiting program. Her areas of practice including copyright, trademark, design, and the data privacy matters, advice, and litigation. She also has expertise in designing a worldwide strategy of protection of creation, especially on the geographical axis France, European Union, mainland China, Hong Kong, and Asia. She is co-directing a master's degree in intellectual property law and the digital law in the Institut Supérieur du Droit. So before we start, please allow me to mention quickly that ENRICH in China will launch a call for community soon, and we sincerely welcome you to apply as a soft landing zone, external service provider, or members to become a part of community. And in addition, from April to May, we're going to organize several workshops related to business development in China. For the workshop in April, and our expert will share the valuable insight about how to achieve and success in the building the strategy partnership in China. And the participant will acquire in workshop the required skill and the knowledge to design and implement a practical plan to develop their own strategy partnership in China. And we will have the discount apply from Wednesday and to April 14, two for the price of one. And the flyer will be sending out on Tuesday. And for the workshop in May, the topic is about business communication in China, developing the successful public relation and the media strategy. And this interactive workshop is designed to help the participant reach and attract Chinese customers, as well as building a positive brand reputation in Chinese market. In addition, they will gain the better understanding of the ever-changing Chinese market and to connect with the right partner to open doors in China. And also on the 27th of May, we will have the Smart City Forum. It's called the Next EW. This event will allow participants to attend online exhibitions and on-site demonstration in the area of smart infrastructure, smart transportation, and smart industry park, and smart home. And directly interact with the Chinese representative focused on the 5G, base station on drone, autonomous driving, vehicle, and voice control elevator, and also other technology. So if you are interested in these events, please do not miss them and to register as soon as possible. And if you have any question during this webinar session, please feel free to send your question in the control panel during the presentation. And we will then answer those questions in the end of the webinar. Okay, now let's welcome Ms. Alessandra Caprilia to give us overview of China IP SME Helpdesk. So Ms. Alessandra, the floor is yours.
All right. Thank you very much, Johnny, for your introduction, and many thanks, ENRICH in China, for co-organizing this webinar with us, and of course to our IP expert, Catherine, for sharing her expertise with the attendees. Yes, my name is Alessandra Caprilia. I am project executive for the China IP SME Helpdesk. So in a nutshell, the China IP SME Helpdesk is a EU non-profit project advising European companies on IP protection when doing business in China. The project was launched in 2008, so it's been already almost 13 years, as the European institutions saw that, especially in regards to more complicated third markets, SMEs do not have an understanding of the complexity of intellectual property, which is a matter considered to be expensive and full of jargon, legal jargon. Yet it is a crucial factor for a successful internationalization. The Helpdesk represents a sort of intermediate step for SMEs to make more informed and strategic decisions regarding their IP when doing business in China. We not only cover mainland, but also Hong Kong, Macau, and Taiwan, each of them having a different legal system to protect and register intellectual property. In the last 12 years, we have assisted over 100,000 SMEs from European Union, but also from potentially future member states such as Turkey, Bosnia and Herzegovina, Montenegro, and so on. More specifically, we offer free initial advice to SMEs in the form of one-on-one advisory, and by providing a series of online tools to better understand SMEs' assets and how they can leverage their IPR in China. SMEs can write us through our inquiry helpline and submit any question related to IP protection in China, and they will receive a reply within 3 working days. Of course, all questions are treated confidentially in accordance with all EU data protection guidelines. The Helpdesk website is full of information such as guides, regional fact sheets, e-learning module, and all our material and services are of course free of charge. Okay, so here are 2 examples of the material that we offer. On the left-hand side, you can see the IP fact sheet of mainland China. So it is a general overview of the legal framework of intellectual property in China. And on the right-hand side, you can see an infographic about trade secrets protection in China. There are similar initiatives supporting European SMEs with IP protection and enforcement, specifically within Europe, Latin America, Southeast Asia, and India. So feel free to reach out to them if these regions are of your interest to receive similar support. Welcome to connect with us on social media to be up to date with our activities and publications of useful material. And I'm happy to give back the floor to Johnny, and thanks again for today's training. And of course, welcome all participants to ask questions in the chat box. Catherine will address them during our Q&A session. Have a good day, everyone, and enjoy the training.
Thank you, Alessandra, for your overview of the China IPR Helpdesk. And then let's welcome Catherine Heng Yee to talk about the training on the IP protection in China for innovative European SME. So Catherine, the floor is yours now.
Thank you, Johnny. Thank you everyone for attending this webinar. The aim today is to give you an overview of the different intellectual property rights that are at your disposal when you are the creator or at the initiative or creation of a product, of a service, and that you plan to scale it to China. In the next slide, you will see the different topics that will be addressed. In the next slide, there are a list of topics that we will be addressing today. And it goes from the different intellectual property rights that exist in China. Why is it important for you to consider registering your intellectual property rights, to how you can enforce them. We will also be talking about the new patent law and the new cybersecurity law. Now, first point in the next slide is why. Why are we talking today about intellectual property rights? Why does it matter to you, and why you should consider it before you enter the Chinese market, even if you are in the plane of finding a partner, a manufacturing partner or a supplier in China? As you may know, an intellectual property rights is a territorial right, which is enforced only within a specific geographical area. Meaning that, for example, if you already have, let's say, a patent or trademark or copyright in your local country out of China, your existing intellectual property rights only has effect in your local country. But as long as you haven't applied for protection in China, then the fact that you have already this protection in your local country doesn't mean that you'll be able to enforce it in China. In this aim, you will need to apply for intellectual property protection in China. One of the advantages when applying for intellectual property rights is that you have an exclusivity with the subject matter for which you applied protection for. It means that in the case where you are doing business in China, if you applied for an intellectual property rights in China, you have the exclusivity within this territory in mainland China to enforce it. meaning that if a third party, should it be a competitor, should it be your former partner in business, if he has committed any infringement, if he copied your trademark, your copyright, or your patent, because you have an IPR in China, you will be able to enforce it and so to stop the infringement committed by a third party. It is very important to consider intellectual property in China. One of the reasons is because China has, as many other countries, a first-to-file system of registering IP rights. It means that the first entity who applied for IP right will be the first who has the right to register it, unless you be able to prove that he registered this trademark, this copyright, or this patent in bad faith. So this is really important for you to consider these IP rights. Now, moving to next slide. Now that we've talked about why is it important to apply for intellectual property rights, what are they? I mentioned them. They consist of, depending on the kind of creation or innovation that you have put in place, it could consist of a trademark, a copyright, or patent. Bearing in mind that in China, there are 3 different kinds of patents that are protecting different kind of invention. The first one is the invention patent, the second one, the utility model patent, and the third one, the design patent. Now, there is also a protection that you may have, which consists in trade secret. It consists of being able to have protection on a knowledge that is confidential, secret, and for which you have put in place certain technological measures and also physical measures to protect its confidentiality. It could consist of a know-how or a specific secret as regards how you are manufacturing a product, for example. However, trade secrets are not considered as intellectual property rights, but I mention it here because in practice, it could be also of particular importance. Now, moving to next slide, we are now focusing on the needs of small and medium European companies, so that you know there are international companies who have been encountered some issues with their intellectual property rights. And I'm naming here 2 famous companies that you may know. The first one is iPhone and the second one is Muji. These 2 companies, even though they have international lawyers who are handling their intellectual property matters, have been encountering some difficulties in sometimes registering their trademarks or even the patents in China. And one thing that is interesting is the quote made by the CEO of Muji, who recently lost a battle to make him register the Chinese characters of its trademark Muji, which you can see here on the screen. It was not able to register these Chinese characters because it was not the first one to file these characters as a trademark in China. Before Muji entered the Chinese market, there was actually a local Chinese company who already a few years ago applied and get the registration for these Chinese characters. And therefore, because Muji was not able to prove that its trademark was well known in China before the third party registered for this trademark, it was not able to use it, which resulted in the consequence that in China, Muji is not able to display this Chinese character as a trademark. So there is one quote from the CEO of Muji based on this experience is that he gives the advice, secure your own right first when you are considering expanding your business overseas, especially in China. And this is the topic we are talking about. In the next slide, I will be focusing on the this trademark experience which big companies such as iPhone, Apple, and Muji experienced. The first advice that is very important to consider when you are launching a product in China, whether it be a product or whether it be a service. You have to consider registering your trademark both in Latin and Chinese character. When you get a trademark, see it as a whole, meaning that first of all, of course, you may be willing to apply for a trademark, which is the same in your local country, in all over the European Union, and also in China, because you have consumers who know you as this trademark. But also, you may want to consider choosing and very carefully choosing the Chinese characters of your trademark. The Chinese consumers, as well as other consumers of countries who are using a different alphabet than Latin characters, have a special link with their local writings. And this is very important for you to consider this, because you may not ignore that a lot of local companies are really seeing registering a trademark as an opportunity to make money and to be able to sell you the trademark which you wanted at a high price, because you lack the vigilance of registering and applying for a trademark in Chinese character. So please consider it before you expand your business in China. In practical, as we can see in the next slide, as regards a trademark, before you file a trademark application, this is very important to conduct prior search. A prior search is a procedure by which you will have a global overview of all the existing trademark applications as well as registration which are valid in China. This way, when you are able to see what are the third party's rights over a trademark, you will be able to choose rightfully the trademark that does not constitute an infringement of other party trademark. This is the first advantage of conducting a prior search. And the second advantage is that if you have noticed that a third party has a similar trademark than yours, then you will be able to change your plan, to change your trademark project, so that you can really choose a sign that is distinctive, that is very specific to your own business, to your own product and service. After this prior search is conducted, which is a recommended step before you file a trademark application, then you can apply more with more tranquility with the trademark application with the Chinese office. And then after you have made the work of choosing the right Latin and Chinese character trademark, you can obtain a trademark registration, which consists of a certificate which will enable you to enforce it before courts, but also before the local administrative authorities in case you suspect anyone of infringement of your rights, meaning if somebody copied or very launched a very similar product to yours, you will be able, thanks to this registration, thanks to these certificates, to prove that you're the owner of an intellectual property rights. Now, in the next slide, as we mentioned before, there are different kinds of intellectual property, and besides trademark, which is an important asset for your company, you should also consider filing a copyright registration. As you may know, copyright aims to protect the original creations, which may consist in computer programs, website content, music, graphic design, logos, text, and scenario. The copyright aims to protect the expression, the tangible expression of an idea, and not only an idea itself. Bear in mind, please, that all ideas are not subject to intellectual property protection. Only if you have really expressed your idea with some concrete and tangible expression, you will be able to claim for protection for it. Besides trademark and copyright, we also have an important asset for innovative technologic company, which consists of patents. The patent is an intellectual property rights which enable you to have an exclusive right that is granted for an invention, which may consist of a product or a process that provides something new to what has been done before. It consists of a new technical solution to a problem. As I mentioned before, there are 3 types of patents in China that you should consider, bearing in mind that the conditions of a patentability, meaning of the possibility of obtaining a patent, are the fact that this invention, this new solution to a technical problem should be new. It means that you shouldn't have disclosed your invention anywhere in the world before you apply for patent. The second condition for applying for patent and obtaining patent protection is to be able to have a process or product that you can apply at an industrial scale. And the third one, as I mentioned, you should consider your new product or your new process as a technical solution to a problem. These are the 3 essential conditions for obtaining a patent protection. When you are developing a new product or a new process which you deem may be able to patent protection, it is very important to bear in mind that you may apply for patent at an early stage. You should really put in place when you're discussing within your employees, but also with your partners, the fact that your new product or process may be protected by patent. And because it's a valuable asset, third party may be interested in applying for intellectual property before you do, especially in China. So this is very important for you to put in place some non-disclosure agreement within your company. So it means with your employees working for you to make sure that they will not disclose the new product or the new process that you're working on with third parties, but also with your potential partners to be sure that they will not apply before you and in bad faith such new product or process. Now, to put it in a nutshell, the first kind of patent protection, the invention patent, aims to protect new technical solution or improvement to a product or process that may be existing, and it provides you protection for 20 years. It is very one of the most important assets that you can have. The second kind of patent is the utility model patent, which aims to protect only products with a new shape or structural physical features. This is a kind of patent that is for now protected for 10 years as from the date of filing, and not 20 years as for the invention patent. And the third kind of patent you may apply for is the design patent, which aims to protect the external features of a product, meaning the shape, the pattern, or the color of a product. And as well as for the utility patent, a design patent may protect you for 10 years. Now, moving to the next slide. You should be aware that there is a new Chinese patent law that has been enacted and which will have effect as from 1st June of this year. This new patent law will be completed by all the regulations in China, which we are awaiting right now. But bear in mind that this new patent law will aim to provide a more comprehensive and more protection for patent owners. For example, one of the provisions of this of this new Chinese patent law is that the invention patents protection term may be extended beyond 20 years in certain conditions. For example, if the patent has been granted 4 years after the filing and that it has been granted 3 years after the date of requesting the examination, the Chinese law provides that the patent applicant may request a compensation period for the unreasonable delay in the granting process of the invention patent. So the idea behind this law is really to compensate any delay in the granting of a patent to enable the patent owner to have a very significant patent protection. Moving to next slide, there is another circumstances under which invention patents may be extended beyond 20 years. This is the case where you have applied for the approval of a drug in China. In the same circumstances, if the Chinese local intellectual property office has taken more time than reasonable for you to get the review and approval of the drug, then you can apply for an extension of the patent term protection. In next slide, I will explain to you that the Chinese new patent law has also designed an extension of the protection for design patent applications. As you know, now a design patent may be protected for 10 years. And as from next June, this design patent protection will be extended to 15 years. Also, this Chinese new patent law has put in place the principle of good faith as regard patent application and use, meaning that any patent applicant may not, through a patent application, have the intention to harm the public interest or others' legitimate interests. Meaning, for example, that if you encounter one of your former partner or former manufacturer who applied in bad faith any patent application, then you can criticize the good faith behind this patent application and claim it before the Chinese local intellectual property office. Also, this new patent law has put in place some punitive damages in case of patent infringement cases. The aim is really to deter any third party that would be willing to infringe, to copy, to put in place a similar invention than the one in place by good faith patent applicants. So in circumstances where an infringement is deemed intentional, or there are serious circumstances under which somebody applied for a patent, whereas the intention is not really to claim for a monopoly or an exclusivity with regard to an invention, but rather to prevent a good faith party from obtaining a patent, then the damages that you will be able to claim during a civil action or criminal action will be really determined. This is the aim of this Chinese new patent law. Now, moving to the next slide, we will see how the intellectual property rights are useful. We know that it provides you for a monopoly and exclusivity to use your IP right in China, especially. And how can it be useful in case you notice that somebody copied you or issued a product, launched a product or process in the market which is very similar to yours? Based on your intellectual property right, you will be able to put in place some preventive measures, but also to take actions in the administrative level, but also on the judicial level. So first one is that based on your intellectual property rights, you are able to take some preventive measures consisting in registering your intellectual property rights with the customs. And by customs, I mean two kinds of customs. The first is, of course, the one that are located in China. The aim here is to register your intellectual property rights with the local customs so that they get to know more about your products and your intellectual property, and to prevent any export of infringement of infringed items overseas. The second side of this customs procedure that you may take action is in your local country. For example, let's say that you manufacture your products in your local country, depending where you are located. You can also register your intellectual property rights, bearing in mind that you should apply for protection in your local country with your local customs. This way, you prevent any import of infringed goods from China, but also from any other countries that enter your local country. This is very important to put these actions in place. Second kind of action that is possible when you have an intellectual property rights is the administrative action in China. Chinese authorities now, it's been many years that are very acquainted with the importance of stopping infringement, and some administrative authorities have large powers to stop any infringement activities. One of their power, which is very important, is the ability to raid some suspects' premises, seize and destroy infringing items, so that these infringing items may not be marketing, may not be commercialized in China. They also have a power in imposing fines for example, trademark infringement, copyright infringement, and counterfeiting patent certificates. The administrative action is very much, I would say, a fast way and a cost-effective way to deal with trademark and copyright infringement, but also to gather evidence for patent infringement. This way, you ensure that a local authority have seized some infringing items, and that you will be able, depending on the amount of goods, but also of the value of the goods that have been seized, whether to obtain the destruction of the goods or also to keep this evidence for a further judicial action. Now, the third kind of action you can put in place when you encounter that somebody has copied you, or has launched a very similar product than yours, is the judicial actions, which can consist of two kinds of action. The first one is civil action, and the second one is criminal action. Now, in practice, civil action will be available to you if you want to have remedies, meaning that you want to have some benefit that consists of getting some damages, or also getting the order from judges to destroy the infringed goods. Civil actions are very useful tool if you want to obtain such actions. So these results. Besides civil actions, you may also want to take another initiative which consists of criminal action. This kind of action can occur actually in three kinds of situations. The first one is, of course, when as an intellectual property right owner, you decide to file a criminal suit because the threshold that are put in place by the Chinese regulation are met, and the qualification requires that you put the person that you have arrested before the criminal courts. Or also, the other situation where criminal action can occur is when you report the case you have at hand to a local authority called the Public Security Bureau, which transfer the case to the criminal authority. And the third one is when the administrative agency transfer the case to the criminal authority so that the criminal action can be initiated. Just to let you know, now in China, there are very much a lot of IP specialized courts. So the Chinese authorities are much more acquainted to what are IP rights and what are infringement. In the three most important cities in China, there are three IP courts in Beijing, Shanghai, and Guangzhou. But now also all over China, they have created 18 specialized IP tribunals, meaning that now the courts, when they see and they handle your case, they're much more knowledgeable. And when you are talking about your IP rights, they are now able to handle it with ease, and they have precedents on which they can rely on. If you have any questions as regards the intellectual property rights, please do not hesitate to ask them in the chat, and I'll be happy to reply to them. Linked to the intellectual property rights and how to secure your technology scale in China, we're now moving to the next slide, talking about the technology transfer. Beside the intellectual property rights, you have a part of your business which will consist in searching for maybe some local manufacturer or suppliers of your products or your services. And there are some things that you have to keep in mind in order to be fully protected. First consideration is things to do before you transfer any technology. The second kind of consideration is when you are in the process of drafting a contract, of negotiating a contract with a partner. And the third consideration is what you should be aware of and what you should monitor after the transfer of technology occurred. So first one is before you transfer any technology to a local partner in China, what you should be aware of. First of all, what is technology transfer? Well, technology transfer is a broad expression which can encompass any process of transferring your knowledge, the technologies and the know-how you have to other entities in China, maybe a scientific and technological company or a manufacturer or simply a distributor in China. And the knowledge that is the subject matter of the transfer technology may include some scientific knowledge, some technological developments that you have made, etc., etc. So first of all, before you put in place any technology transfer to a local partner in China, you should consider filing intellectual property protection first. Before you operate the technology transfer, it is very important that you ensure that you file IP protection first. As you now know, China has a first to file system. So you need to ensure that you are the first and that you are in the process of obtaining some intellectual property registration. The second consideration you should have in mind before you put in place the transfer of technology is to include some confidentiality provision in the contract, especially if the subject matter are not protected by an intellectual property right yet. You should really include such confidentiality provision with your employees, but also with your partner. Please bear in mind that the confidential provision should comprise any IP protection you fight for, any IP registration you obtain, but also any trade secrets and know-how that you're going to share with it. Now, moving to the second consideration you should have is what you should do when the transfer of technology occurs, you should really consider how you're going to transfer this technology. I now give you some attention about some local regulations in China, consisting in sometimes you will have some local regulation that will constrain you to transfer the technology to a Chinese company. This is what we call a compulsory technology transfer. But if possible, if you are not under this Chinese regulation where you are compelled to transfer the technology to China, we recommend at any time that you choose the form of licensing your technology rather than transfer the ownership of your technology to your partner in China. The license of transfer of technology is the permission that you grant to your local partner to use the intellectual property in certain circumstances and for a certain amount of royalties. In the circumstances in this framework, when you have a license of IP, you still retain the ownership of the intellectual property, whereas your partner has the right to use it. We really recommend it so that in this way, you still have the ownership of the IP, and in case your collaboration or your partnership with this company does not go well, you can still retain this ownership, put an end to this contract, and then conclude a new license with another partner. As regards licensing, we also have another advice for you is to choose whenever possible different suppliers for every component of your product, so that in consequence you do not rely on a single supplier to make your final product. This is the case when you intend to manufacture your products in China. Ensure whenever possible that you have not only one unique supplier, but different suppliers for different components of your products, and make sure that you conclude license of technology transfer with each of your partner. After you establish the technology transfer contract, you need to nurture a good relationship with your partner. This is very important. Beside the legal aspect of a relationship and of a contract with the partner, as you may know, there are some cultural differences, and there are ways of nurturing a good relationship. So make sure that you and your partner have a good and the same understanding of the contract, of the rights, but also the limit of use of your intellectual property. Make sure that this contract includes some confidential provisions so that your partner may not be able to disclose any of your confidential information to any third party. And also, based on the experience, it's not too much to ask you to monitor your activity in China, which consists of, let's say that you have filed an IP protection in China, an intellectual property protection. Ensure that your partner did not file also an IP protection as regards the subject matter of your collaboration. If you notice that your partner has filed any IP protection or developed a very similar technology to use, it is very important that you act immediately and that you react immediately. And To do so, you need to monitor really the activity of your supplier and to keep an eye on the kind of products that are launched in China as regards the product or the services that you have launched out there. If you have not, if you have any questions as regards the technology transfer, please ask them in the chat. If you have not, I suggest that we move to the next topic and the next slide, which is the cybersecurity law that took effect in China in 2017. As the audience is entirely composed of European companies, as you may know, in Europe we have a data privacy legislation that was put in place in 2018, which is the GDPR. So it's the general European regulation as regards personal information. The US also have their own kind of GDPR regulation, their personal information regulation. And China also in 2016 enacted a law called the cybersecurity law. This is very a global movement in the world for every geographical authorities to have a localization of the data and to ensure that the personal data which concerns the citizens remain processed by local entities, and that there is no leak of information outside of their territories. And this Chinese cybersecurity law really is in this movement of, I would say, data localization, which every regional authorities aim to do. So it aims to provide some cyberspace sovereignty for China to protect the national security interests, and also to protect, as I told you, the fact that the personal information as regards Chinese customers, as regards Chinese citizens are processed on a local basis, even though they may be processed by non-Chinese entities. So actually this cybersecurity law regulates two types of organization. The first one is what they call the operators of critical information infrastructure. And the second one is the network operators. So first one, operators of critical information infrastructure. There is not, I would say, clear definition of what concretely are these operators of critical information infrastructure. But if we make an analogy with the EU regulation, for instance, this concerns any entities that process information as regards the telecommunications, the information services, the energy transport, the water, the financial service, and the public services. For these entities, this regulation required them to store the personal data and other important data in China, unless there is a strict necessity to send this data abroad. And in such a case, the text provides that the Chinese authorities have a right to review the security of this infrastructure. The second kind of operators that are in the framework of the cybersecurity law are the network operators. Here again, there is no clear definition of what is a network operator. But basically, what we can notice is that it includes any organization that operates a computer network in China. even though this system put in place is entirely internal to this organization. So basically, under this regulation, the companies, including any Chinese affiliates of foreign companies that set up the cloud infrastructure, including the servers, the virtualized networks, software, and information system in China, they should set up such system in China so that the customer's data and the user's personal information are processed by cloud service providers stored inside China. In practice, what we have noticed is that many companies that are processing with data in China, and there are a lot, they are separating their Chinese data from their other data. Let's say you are a company operating both in Europe and in China, then you should really consider separating the infrastructure, the information technology of these two systems, so that in case there is a review of your security system by the Chinese authority, they do not have a review of the data that you have that are processed outside of China. This way you ensure that the review is really limited. There has been some fear about the investigative powers of Chinese authorities into the company's IT systems. So the first thing you need to know is that China recently put in place some national standards. It consists of some cybersecurity protection standards that you should put in place to avoid any leak of information. So we are still waiting for some clarification and further text as regards the national standards. But for now, what we know is that the companies are classified into 5 different level 1 to level 5, depending on the vulnerability of the IT systems they may be confronted to, and you should consider really when you are dealing with some personal data of Chinese customers, but also data in general when you're operating in China, to put in place a system that is really secure so that there is no leak of data, or to prevent any unauthorized access of your data from abroad. So the aim is really for the Chinese authorities that the personal information concerning Chinese citizens really are stored in China. So if you have any questions as regards the topics that we have now been presented, please feel free to ask them, and I'll be happy to answer them.
Okay, so thank you, Catherine, for your excellent and very detailed presentation on the IPR. So we have the few questions. So the first one is about, I heard that a foreign company, even if it registered its patent in China and never wins on the court again, a Chinese company infringing the foreign company's patent. So what is your opinion about it?
It's very difficult to provide a very general response because, as you may know, everything related to patent infringement, patent cases, and in general intellectual property cases that are brought before the tribunals, the results, the decisions that are made by the judges and the tribunal really depends on the facts, on the IP rights that were registered, the IP at stakes. As I mentioned before, if we take the example of Apple or Muji, even big companies, as you can see, have made mistakes and learned from their mistakes. I am not aware of the details of this case. However, again, I would like to stress the importance of really conducting an audit of your intellectual property rights. Do you know where you have registered your patent? Have you filed first your patent in your local country? Have you filed it in China before you enter the Chinese market? Have you obtained your patent registration? These are two different steps in the patent rights process. First one is filing, but after filing you have registration, and only if you obtain the registration of your patent, you have patent rights over the subject matter. So this is very important to have this in mind. If you have obtained a patent registration, then you really have a monopoly over what you have registered for. So you have a strong position in your market. So I don't see why Chinese, there is no specific reason to consider that a patent that are registered will be not well protected.
Thank you. Okay, and we have the second question. So how will it happen if the understanding the IPR protection is based on the very different regulation and containing the cultural difference?
Is it possible to repeat the question just to ensure that I understood it right?
Yes. So how will it happen if he understanding of the IPR protection is based on very different regulations and containing the cultural difference?
Okay, so if my understanding is correct, the question is about the different criteria by different countries to grant intellectual property protection, and also the cultural and I would say local appreciation of what is an infringement or not in practice. This is a very interesting question. Thank you for asking it. Actually, as we introduced this webinar, intellectual property rights are territorial rights, meaning that, as the person noticed, when you apply for intellectual property protection in China or in France or within the European Union, there might be some differences in the criteria for protection. So first of all, of course, when you're considering having a worldwide intellectual property protection, make sure that you identify the countries which are of importance to you, and then effectively check out the criteria for intellectual property protection for each kind of intellectual property that you are interested in. And once you have applied for it, you need to wait for the registrations that you can ensure to have an IP rights with effect. And second question, as regard the local appreciation of some infringement, you are totally right. Based on my experience, whether in France, within the European Union office, or in China or any other countries, every country is actually, I would say, has a different appreciation of what is similar and what is not, what is identical and what is not. And for this purpose, it is very important that you have the assistance of a local council that has the experience of what is deemed similar or not in your country, whereas will it be in France or in European Union or in China. This is the local eyes and the local experience is very something valuable. And you may not consider, because you have you have win, let's say, an infringement case in France, that it would be necessarily the same in another country or in China especially. Because indeed the appreciation of a similarity and of an infringement is different. And so before initiating any, I would say, action, would it be a judicial action, administrative action, you need to have the assistance of a local counsel or somebody who has some experience in this field to give you another view of your chances of success.
Thank you, Catherine. And we have the one last questions. So the last question is about, so we saw some cases that a few Chinese companies or young scientists are prompt to apply for the patents as a copy of what they have learned from the literature or for the products they have purchased. As they might not be officially registered in China, so how could one protect themselves by objection or turning down the Chinese application or already few patents?
Okay, so if my understanding is correct, these questions concerns the fact that some local Chinese companies have applied for patent application, whereas these are not truly patent application, I mean good faith patent application, if my understanding is correct. So one of the consideration you may have when dealing with these with these circumstances, if you notice that a local company applied for a patent application which has not been made in good faith, I suppose that you, on the contrary, may be the one who have developed something that could be protected by patent application. Then you should really distinguish your situation. Let's say that this local company was your former partner, or maybe was somebody with which you were in discussion with to protect your patent or to transfer any knowledge. You should really keep the evidence of your relation with this person so as to be able to criticize the good faith of this patent application. To this aim, you can approach the Chinese local intellectual property office and how to say, and to claim the fact that this patent application is not eligible for protection because of the context that you have had with this company. If you have not had any contact with this Chinese patent application, then it's really tricky. You have to consider that there are some research to be made as to how it is possible to criticize the validity of the patent. And yes, this further research needs to be made. But let's say, for instance, in Europe, there is a regulation according to which, after an intellectual property rights has been granted, third parties may criticize the validity of an intellectual property rights. So there is some research that can be done in this. To ascertain this question. Is there any other questions?
I think there is an interesting question in the chat about the fact, is there a way that the EU could run a joint court for some IPR dispute? Because the dialogue between EU and China has been going on already for some time, and there are already ongoing projects like IP Key for China. Do you think that there could be some joint court one day?
Interesting. The idea of joint court is really interesting. it has to be on the table of the EU, I would say. It's something interesting. However, bearing in mind that IP protection is really limited within a geographical area. There is actually what we call in law jurisdiction competence that is at stake, which is very directly linked to sovereignty, the sovereignty of a country. So let's say you have an intellectual property protection issue which concerns a Chinese patent with an EU company. Even though an EU company is concerned, the main issue at stake relies on a Chinese patent which has been granted by the local office, and therefore it seems really difficult to invite the EU to take part in how the Chinese local authorities will consider the patent infringement issue. This is really a consequence of the fact that the IP are territorial rights. But this is an interesting thing that I would say is beyond my competencies as a lawyer, but on a political and political, I would say, point of view, this is really an interesting idea.
So many thanks, Catherine and Alexander and Johnny. I think we don't have more questions. We'll follow up also with all the participants. And I think there was also a question here about the presentations. So we'll follow up, and also about the WeChat. If we have a WeChat group for ENRICH in China. So if you wish to be added to the WeChat group, you can write us to this email address, and then we can add you. And any other questions also to our speakers from today, Alexander and Catherine, let us know, and we'll try to follow up directly with them. So many thanks, Catherine and Alexander, for being with us today in this webinar. I think was very useful to all the participants. Many thanks, Johnny, for the great moderation, and many thanks to each of you for joining us this 1 hour and 15 minutes. And please stay tuned to the next ENRICH in China activities, and anything, just write to us, and we'll be very glad to cooperate with you. And please be safe. Have a nice day in Europe and a nice evening in China. Thank you so much.
Thank you very much.
Thank you, everyone.
Bye-bye.
Thank you, everyone.
Thank you.